Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case Shelby County, Alabama versus Holder. This case was heard in the Supreme Court of the United States in the year 2013. Let's go ahead and jump into the facts of the case. So to understand this case, we need to understand what the Voting Rights Act is. The Voting Rights Act, or the VRA, was passed by Congress in 1965, and what it was sought to redress was racial discrimination in voting. There's two key sections of the VRA that are at issue in this bill, Section 4B and Section 5. Section 5, what it did was it made voting districts with a history of racial discrimination or racially discriminative policies have to get approval from a three-judge federal district court or the Attorney General before they changed any of their election procedures. Now, 4B was the section of the VRA that defined these jurisdictions that had to jump through this extra hoop to change their election procedures, their election systems. One of these jurisdictions that had to jump through this extra hoop was Shelby County, Alabama. Shelby County, Alabama brought this lawsuit and they challenged the constitutionality of Section 4B and Section 5 of the Voting Rights Act. They said that this was an unconstitutional act of Congress because it was a federal overreach. Their argument was that the state should be able to regulate its own elections, and the federal government shouldn't be stepping in and forcing the states to run an election in a way that the federal government sees fit or in a way that a three-judge federal district court or the Attorney General would approve. So they're seeking a declaratory judgment to say that these sections of the Voting Rights Act are unconstitutional. So the court has to decide whether they're going to accept this argument of Shelby County or whether they're going to kind of hold to the precedent. So the precedent had said that this was a constitutional act. It was okay because there was extraordinary circumstances that justified the federal overreach into the sovereignty of the states in these instances. And so that the precedent was on the side of the Attorney General in the United States, but Shelby County brought this challenge nonetheless. Their main argument was that the extraordinary circumstances that justified this federal overreach have now passed. There's no more extraordinary circumstances with racial discrimination in voting that justify this federal overreach, and for that reason, these sections of the Voting Rights Act should be struck as unconstitutional. So the majority, and Chief Justice Roberts writes for the majority, he says that we are going to specifically target and strike Section 4B. And we do say that that is unconstitutional. He recognizes briefly that, in the past they have held this provision to be constitutional. But the reason why it's unconstitutional now is because it runs afoul with federalism, the 10th Amendment, and dual sovereignty. It also treats different states with less sovereignty than others. It gives less power to other states, right? So if Utah doesn't have any discriminatory voting, but Alabama does, well, Utah can change their election law however they'd like. But because Alabama has a history of racially discriminative voting, Alabama now has to run their election procedures, the changes that they'd like to do to them through the federal government. So they're saying that because you're not treating states with equal sovereignty, and further because you're forcing these states that are targeted to jump through this extra hoop and to be regulated by the federal government when truly they should have their own ability to regulate their elections. So they strike Section 4B, the coverage provision, the coverage formula from the statute, and they say it's unconstitutional. The majority leaves Section 5 out there. It hangs it out there. I mean, it says that we're not going to say Section 5 is unconstitutional. We're just going to say that the coverage formula is unconstitutional because we're treating states differently based upon their history. And Justice Roberts basically says that's long in the past. We can now see that there's plenty of minority office holders. We can see that voting turnout by minorities is even higher than voting turnout by whites in some of these covered states. And so he says the problem has now been mostly resolved in the sense that even if there is a problem, it doesn't justify this vast amount of federal overreach into the sovereignty of the states. Justice Thomas writes a brief concurrence where he says he would strike Section 5 as well because he feels that it is also unconstitutional. There's no rational basis for that federal overreach anymore. Now, Justice Ginsburg writes for the dissent, and this was a 5-4 decision, so weighty justices on either side. Justice Ginsburg says that this is not the role of the court to determine whether there's still racially discriminative practices in voting. This is the role of Congress, and the Constitution expressly gives this right to Congress in the 14th Amendment. It gives it the right to enforce the 14th Amendment. And so we as the court should not be trying to strike laws down like this. We should defer to Congress. She cites to the record very overwhelming majorities voted for the reauthorization of the VRA in 2006. And she's making an argument there saying that, Congress overwhelmingly supports this. And it is Congress's role to determine whether or not there's still racially discriminative practices in voting. And as long as Congress has a rational basis for concluding that their regulations, the federal overreach in this instance, would serve to redress the racially discriminative practices of voting, then we shouldn't be striking this law. That's Congress's role. It's not the role of the courts. She says the role of the court, this isn't an unlimited power. Congress can't overreach ad nauseum here. The court has to determine if there's a rational basis of the regulation to the problem. And she says here it's very clear that there's a rational basis. There is a lot of legislative history, and the legislative record is full of instances of discrimination in voting that still exist in our century. So she says that, let's defer to Congress. This is not our role as the court to strike this law as unconstitutional. All right, so that's the case. Thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.